case briefs, and so much more. LSData's got what you're looking for.
In a landmark Supreme Court case, Pillsbury Company v. Conboy, in 1983 involving former executive John Conboy, the court ruled that a deponent cannot be forced to testify in a civil deposition if their prior immunized testimony is closely repeated or tracked, unless there is a separate grant of immunity for the deposition testimony. This decision sought to protect the deponent's Fifth Amendment privilege against self-incrimination. John Conboy was granted formal use immunity for his testimony in a grand jury investigation into price-fixing activities. However, he later refused to answer certain questions in a civil deposition, invoking his Fifth Amendment right against self-incrimination. The issue at hand was determining whether his answers were derived from his immunized testimony and should be excluded under the grant of immunity. The plaintiffs were purchasers of corrugated containers who chose to pursue their own causes of action against manufacturers rather than participating in class action proceedings. Portions of Conboy's immunized testimony were ordered to be made available by the district court, but during the deposition, Conboy repeatedly refused to answer questions while invoking his Fifth Amendment privilege. Ultimately, the Supreme Court held that a district court's compulsion order could not be justified by the later exclusion of compelled testimony without statutory authority or a new grant of immunity by the United States Attorney. The court stressed that private civil actions could not replace the government's primary responsibility in enforcing criminal laws. As a result, a deponent's civil deposition testimony was not considered immunized testimony under Section 6002 without proper authorization, and could not be compelled over a valid assertion of the deponent's Fifth Amendment privilege.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.